Hi, I'm Quintella Griffin with Realty, and today I will be doing a presentation on probate listings and inherited properties with a mortgage. Hopefully, this presentation will help you find the right listing agent for your probate sale, trust sale, or inherited properties and help you resolve some of the issues that arise when you are in a probate sale. Thank you. Hi, before I begin this presentation, I must do a legal disclaimer. The information you're about to obtain in this presentation is not, nor is it intended to be legal advice. I should tell you now, I'm not an attorney. I am a realtor with a legal background. I worked at law firms for like 25 years, and I did legal secretary work, paralegal work, and all types of different things, worked at legal departments. And so I'm not alleging to be an attorney. You should consult with an attorney for individual advice regarding your own situation because every situation is different. The information in this presentation is not a substitute for personal legal advice, neither. Ward's Realty and any of its subsidiaries, real estate agents, or agents of the company do not endorse any particular attorney or legal service, make no representations, guarantees, or warranties, express or implied, as to the legal ability, competence, quality, or reliability of any legal services provided by any lawyer services. So I'm going to be referring legal services to people. I will also be referring loan officers. And so this is just a disclaimer so you understand that I am not providing legal advice to you. And if you have additional questions, you should definitely consult with an attorney about the subject matter here. Thank you. Hi, before I get started on this presentation, I just want to give everyone a little bit of background before probate begins. What should usually happen, which most of the time does not happen. So we need to take a moment and think about what estate planning is. A lot of people do not even have that word in their vocabulary. So let's go over it. How an individual's assets will be preserved, managed, distributed after death. It also takes into account the management of an individual's properties, financial obligations, in the event that they become incapacitated. Incapacitated is they get in a car accident and they can't function anymore. Or they get sick and something happens and they don't function in the same capacity as they normally could and they're unable to take care of themselves. Assets that could make up an individual's estate include houses, cars, stocks, paintings, life insurance, pensions, and debts. Individuals have various reasons for planning an estate, such as preserving family wealth, providing for surviving spouse and children, funding children and or grandchildren's education, or leaving their legacy behind to a charitable cause. So this is really important that we understand what estate planning is and how probate comes into play as a result of not doing any estate planning or failing to update your estate planning or just not leaving any instructions upon passing away or becoming incapacitated. Again, before probate begins, the most basic step in estate planning involves writing a will. This is very basic. A lot of people don't leave a will and they have to go through probate, or they don't have a living trust. Other major estate planning tasks include this is part of estate planning: limiting estate taxes by setting up trust accounts in the name of the beneficiaries, establishing a guardian for living dependents. So say like you have children or you're married and you have children and you pass away and you haven't left any instructions or no estate planning tools that would tell someone who's going to be taking the kids. They could end up becoming a ward of the state or foster care. A lot of things could happen. And I know sometimes people think, well, they have a father. Well, what if you're going on a vacation and everybody gets killed except the kids? And I don't mean to be morbid or anything like that, but I'm just being straightforward and direct about this topic, which is a topic that many people don't like to discuss, but is something that needs to really truly be addressed among adults. Estate planning, which leads up to a probate sale. Naming an executor of the estate to oversee the terms of the will. I cannot stress enough how important it is that when you do your estate planning, if you create a will or a living trust, it doesn't matter what type of tool you use, that you leave an executor, a personal representative, someone that's going to oversee it. And this person that's going to oversee it, it has to be someone that is really beyond reproach, very trustworthy. And I've seen a lot in probate where some siblings feel like because I'm the oldest that I'm going to take control, or some siblings feel like I'm not going to disperse their funds. It's a lot of things that go on that create a lot of bad things to transpire. I'm not going to go into that, but you could just imagine the things that happen when you don't leave the name of an executor, and you really should like do more than one executor is what I see from what I've been experiencing with probate sales. Maybe a co-executor, or just someone that more than one person, so you can kind of like have a check and balance and make sure that things are done right, so you don't end up in court. It's always good to have more than one person. um, Creating slash updating beneficiaries on plans such as life insurance, IRAs, and 401k. A lot of things can be done without even doing estate planning. I mean, like, most people don't even think that if they have a bank account, just go name who you want the beneficiary is, so the person doesn't have to wait 45 days to see if probate is going to be filed, or where the living trust is. All of these types of things, just, it's real simple. You go down to your bank, you ask them, can you fill out a beneficiary form? A lot of people open up bank accounts and they don't fill out the beneficiary forms. They don't fill out the beneficiary forms for the life insurance policies, IRAs, 401k accounts. And then what happens if there's no named beneficiary, in the state of California, it will go to the um, Secretary of State Comptroller's Office for unclaimed properties and monies, and will sit there. And this is the thing, most people don't know how to locate it, because they're thinking, oh well, if my aunt or my dad or my mom or a family member left me something, then I should be able to find it. And they're searching in these unclaimed databases under their name. The appropriate search would be under the name of the decedent, the person that passed away, because that person didn't have a beneficiary in your relative, so they wouldn't know to look for you. So it wouldn't be in your name. It would be name of the decedent, the deceased person. So that's just a tip. If you think that somebody may have left you something and you're searching in these unclaimed databases and you don't see your name in it, don't search under your name. Search under the name of the person that passed away. Setting up funeral arrangements. I mean, like, some people want to be cremated, some people want to, don't want to be cremated. It's all kinds of instructions. With estate planning, there's no arguing with family members because it's in writing, and everybody knows what that person really wanted. It comes directly from the horse's mouth. Establishing annual gifting to qualified charitable and non-profit organizations to reduce your estate taxes. You can do that. Setting up durable power of attorney to direct other assets and investments. So all of this is incorporated in estate planning. And when a person passes away and you have to go through probate because they used a will, it makes it really simple, because you don't have to try to figure out what the person wanted on this list. And this list is not the total list, it's just a few things. But this is the beginning of probate, and how it comes about, because people don't do any estate planning. So you have to file, if you have a will, you'll file probate. And if you have a will with all this information in there, that makes it a lot easier versus if you didn't. Okay. I hear this pretty often from people, and this is really just a fallacy and a common mistake made by many people. They believe that estate planning is for the rich and famous. I don't need Why would I go do estate planning? Why would I go talk to an attorney about estate planning? Because if you pass away, you're leaving the burden of all these decisions to be made by family members who may have conflicting thoughts, beliefs, or feelings um, about how it should be done. So you should talk to an estate planning attorney. And estate planning is a tool that's used throughout your entire life. So say you're 25 years old when you first do your estate planning. Well, by the time you get 30 or 40, you'll probably get married, you'll probably have children. So it needs to get continuously updated throughout your life. So find a good attorney that you can work with that will consistently um, update your estate planning tools, directions as you go through your life. So estate planning is designed to leave your affairs in order when you pass away or become incapacitated. It is a tool to be used throughout your life as your life changes. Do not make the fatal mistake of not planning for your death. I mean, it's something that people hate doing. I mean, even me talking about it, I hate to do it, but it's just a part of life. When we are born, we know that we must pass away, and so it's just best to leave your affairs in order. So there's no feuding and differences among your family members. You want everybody to be happy when you pass away, and you don't want bickering among family members and feuds starting that last to eternity where family members don't talk to each other. And I see this when I sell probate sales. There's always someone that is contesting or upset or feels like they shouldn't sell the house or they want to keep it. You know, you know what goes on. You hear about it. You hear about it on TV. You hear about it from your friends. So don't make the fatal mistake of not doing your estate planning. So when I get ready to sell your house, then you won't have these issues. Thank you. So how do we get to probate court? We get to probate court when a person passes away or when a person becomes incapacitated is when you get to probate court. And the petition is filed with the probate court. And that's how it gets started, way before I come into the picture. I'm just the realtor. I don't come into the picture until down the road, and we shall talk about that. Hiring the right realtor for your probate sale. This is very, very, very important. So, the benefits of hiring a certified probate real estate specialist. A certified real estate agent acts as an advisor during the house selling process, helps co-heirs avoid the potential for disputes. You want to keep disputes at a minimum, especially if you're a probate real estate agent or a probate listing agent, because it could really crash your deal. Some of the advantages of hiring a certified probate real estate specialist include selling expertise with an eye towards minimizing risk for disagreement between heirs. That's what I'm talking about. You have to learn to be neutral and not take sides with family members. Um, and don't gossip with them. Just be neutral. Help with the inspections, bids, and home repairs, which is something that you would normally do anyway in the middle of a sale. But sometimes, if they don't want to sell the property as is and they want to remodel because they want to get the most amount of money that they can, you could help them with bids. Me personally, I have a general contractor. If you use me, that will allow my clients to remodel and escrow, so they don't pay for the repairs or the remodel until we close escrow. Help with removal of decedent's personal belongings and property. You know, I'm the type of realtor that I don't mind getting dirty. I can do one or two things. I can arrange to help you have the personal belongings removed from the property, or I could just put on some jeans and get in there and help you clean up. I definitely don't take the position that I'm too good not to be able to do those types of things for my clients. So it's about working together as a team to get the house or your property sold. So I don't have a problem with helping you. Like remove things. I helped clients before gather up clothing and take them to the Salvation Army or donate. It's just you gotta do some extra things when you sell probate properties. Help with disposal of debris and trash at the property. I have someone that can help with that. Trusted advisor during a difficult time. Yeah, you're going to have conversations with some of the heirs. Sometimes they're going to tell you how they feel about another heir, or just, it's hurtful when your mom or your dad or your aunt or your uncle passes away. That's a very trying time in your life. So I try to give as much support during the probate process. Free notary public services. I am a notary. Yes, I am. So if you need free notary services, or you need notary services for whatever, I would make myself available to get that done. A lot of title companies that I work with also would not mind doing notary services for you free as part of the service. And let's see, the last thing on my list, solutions, and this is the most important thing, solutions with distressed properties. I meet people all the time and they just don't realize that their inherited property does not have to go into foreclosure. A lot of people inherit properties that have a mortgage on it or a reverse mortgage. And later on in this presentation, I'm going to tell you how to fix that. Yes, I am. Okay, thank you. Back to hiring the right realtor for a probate sale. I am definitely more than a real estate agent. I wear many hats. I'm a real estate agent. I am a confidant. I will coordinate general contractor. I will go over and check on the property. Um, I will do whatever it needs to be done with the sale of your probate. Um, Here you see, I will guide you from finish to start here. Full service. If you need help with contractors or repairs, that's not a problem. If you need cleanup, anything, financial advisory, you want a 1031 exchange, whatever it is that you need assistance with, I have a resource or a vendor that I work with that can assist you with any and all of your needs. All you have to do is sit down and have a friendly talk with me and let me know what your needs are. I have a network of trusted local experts that will work together with the both of us to help you sell the property and get it ready to sell and to sell the property. Okay. Hiring the right realtor for your probate sale. That's extremely important because it's going to make the difference between the probate sale sitting for months or even years, having potential buyers walk away from your listing, and irritating the attorney because you're just ringing his phone off the hook. So let me tell you what I bring to the table as a probate real estate specialist. I'm a certified probate real estate specialist, and I'm also a paralegal and a realtor. Realtor first, certified probate specialist, and a paralegal. I don't mix the paralegal with the real estate. So you would have to hire an attorney or a paralegal if you needed assistance. But I can maneuver through the transaction, and just so you understand how important this is. Having the ability and the understanding of knowing how to check a court docket. So from my prior experience in the legal field, I'm very familiar with how to check a court docket. So say you have a court appearance or there's an order or something that you're waiting on, for example, a probate order. I'm not going to consistently call the attorney once a week or email the attorney because you get billed for that. Did we get the order? Do we have a full authority? What's the status of the case? Are we ready to sell? Those are questions that can easily be answered by checking the court's docket and knowing how to check the court's docket. And even, downloading documents like the letters or the probate order. I'm familiar with how to do that. So the letters, if it's going to be administered with full authority, you'll be needing letters. You'll be needing letters in general, but you'll need letters. You'll need the probate order. You'll need full authority to sell. And then sometimes the sale is by court confirmation. And I'm going to cover with you what is the difference between selling with court confirmation and what is the difference between what they call independent administration of estates. They have full authority and they have partial authority. What you're looking for when you want to sell the property is you want to try to get full authority without court confirmation, because it just makes it like a regular sale. You just have to submit some of the documents to the escrow and title company, but it's sell by court confirmation. The process is very, very different, and I'm going to cover that here. So one of the things that is really important is understanding how the probate process works, whether you're using the sale by court confirmation or whether you are using the sale by the independent administration of estates. Are all the heirs or beneficiaries in agreement or disagreement? I actually took one of my buyers to look at a probate property that was on sale. They were buyers. I was representing them in the buying process, not on the listing side. And so I walked into the open house, and the first thing I said to the listing agent is this a court confirmation sale, or are you selling by independent administration of the states, and is it full authority or partial authority? She looked at me and said, I have no idea what you're talking about. So that let me know right there that she was not a probate specialist, because that is like one of the main important things. Like if it's full authority by independent administration, I would have told my clients, and this is just me personally, I would have told my clients, my buyers, okay, yeah, let's do this. But if it's by court confirmation, I would have had to sit down and talk to them and tell them, are you sure that you want to do this? Because the process is different. You have to bid. You might not get your deposit back. There's a lot of things with probate. It might take longer by court confirmation. So those are things that you need to be savvy enough to understand how to analyze when you are doing probate listings. Or if you are representing a buyer in a probate sale, you need to know these things. It's very important. Okay, now we're going to talk about probate sale by independent administration of estates, also known as IAE. Those are the abbreviations. So the Independent Administration of Estates Act was enacted in 1987, which it streamlined the probate sale process, so you may proceed um, by these laws they enacted. So it would either be a personal representative, or this person would act as the decedent's estate without you would be acting representing the estate without court supervision. So there's no court supervision under full authority to administer the decedent's estate for a sale of real property. That's under the independent administration of estates. Okay, so there's two different types of sales. There's this one and there's court confirmation. Right now we're talking about without court confirmation. No court confirmation is required this way. I love uh, selling properties that the personal representative has full authority, and there's no court supervision, and there's no hearing dates, there's no biddings, there's no auctions or any of that stuff. It's just like a regular sale, pretty much. The sale is not subject to court supervision or overbid process. The law requiring the price of the estate real property to be at least 90% of the appraised value does not apply to sale under the independent administration of estates. So there's some leeway there. However, the personal representative still has a fiduciary duty to the beneficiaries. That fiduciary duty, we all know what that means. You have a obligation to the beneficiary and the heirs of the decedent to maximize the estate's assets. So you can't be the personal representative and just be like, I am finished with this. I'm tired. I don't want to deal with this anymore. So I'm just going to sell it for the cheapest price that I can sell it for. No, that's not fair to the beneficiary of the or the heirs that you would proceed in that matter. So you want to sell it for fair market value. You want to sell the property for fair market value. Additionally, the sale can be sold for cash or on credit. So it's just like a regular sale, but you just have to do a few little things that you wouldn't normally do in a sale in escrow. And I'm gonna cover that shortly here coming up. Now, when you're closing escrow in a probate sale, this is extremely important. And oftentimes this is something that attorneys forget to do because they're not thinking about the timing with the contract and the timing of closing escrow because they have so much work to do with the actual probate that they sometimes forget. Not always, but it's always good if you have a certified probate real estate specialist with a legal background like myself that can remind the attorney that, we're going into escrow soon. So make sure that the notice of proposed action is submitted and filed with the court. So what happens here with this notice of proposed action, it's gonna get submitted to the escrow and title company. This is really important. There is some language in this form that gives the heirs or beneficiary one last opportunity to object to the sale. So the attorney sends out this form. It's 15 days. They have 15 days once this form goes out to respond and send it back to the personal representative to the court. So we'll just use this as an example. We'll go with a 30-day sale, 30-day close of escrow. We'll say we entered the contract on January 1st and we're closing on January 30th. But the attorney forgets to file the notice of proposed action, or for some odd reason it doesn't get filed. And you're supposed to close on January the 30th. If this document is not filed 15 days before we are to close escrow, escrow will not close. This is very, very, very important. It will extend your escrow, your close of escrow by 15 days. So if you get to day 30 in this document here, you can zoom in and look at this document close, or you can really take a look at it, the notice of proposed action. If within that time frame it's not filed, it will extend there's no way of getting around it. It will extend your close of escrow by 15 days. Probably longer than that, because the title company will proceed with caution, with real caution, and say, okay, well, it's 15 days. Let's see if anything came in, anything trickled in, because it could be that one of the heirs of the beneficiary put it in the mail on the 15th day. So we got to give it a couple of days to see if it comes in the mail. So just consider that your time will be extended probably about 25 days, anywhere from 20 to 25 days, just to be sure. This gives the heirs, again, or the beneficiaries, the last chance to object to the sale of the property. Say, for example, if they're going to contest it, this gives them that last chance to object to the sale of the property. And then you, as the listing agent, would have to let the title company know you're not going to close, or the closing is delayed because there is no proposed action. Now, a notice of proposed action is not always required if there's certain circumstances, but for all purposes, I would always say that the attorney really should just file a notice of proposed action, because I'm going to tell you a story later on down the road, not here right now, but the filing of the notice of proposed action actually saved one of my deals from crashing one time. That was converted from a probate sale to a sale by partition, which, if you understand those terms, I won't go into it, but it saved the deal by filing this document, because the title company wanted to make sure that all the heirs were noticed, even though the judge converted the sale from a probate sale to a sale by partition. The title company wanted to make sure that all the heirs were notified. So we used the notice of proposed action as a tool to serve all the heirs. So if they wanted to object, they had their 15 days to do so. All right, on to the next portion of this presentation. Probate sale by court confirmation. All right. Not my favorite thing, but I'm going to cover it because, as a probate specialist, certified probate specialist, I don't always get to sell by full authority without court confirmation. Sometimes you will, as a certified probate specialist, have to sell and get confirmation from the court. So here's the process. For the sale to be confirmed, the court requires the buyer plus any interested parties come to the probate court to confirm the sale. The property is then sold auction style. Yes, auction style, right there at the courthouse with the opening bid. And so I'm only referring to California. The offer is accepted, price plus the 5% and $500 increments. Sometimes multiple buyers will show up at the bid to bid on the property in increments of $5,000. If nobody shows up to the bid on the home, the first buyer gets the property for their original offer price. If the property is sold to one of the other bidders, other than the original bidder, they must immediately hand over the deposit of 10%. The deposit may not be refundable. There are some things for buyers to be aware of when moving forward on probate sales. The 10% deposit that's required with the offer is not refundable unless the original buyer isn't the final court confirmed buyer. Pay close attention when you are making bids on probate sales and make sure the probate specialist or listing agent, realtor, real estate agent, whomever you're working with, is very familiar with the court process and how it moves in a sale, in a probate sale by court. It's really important. Nowadays, people don't have money to lose or months to wait for the court to process a refund if you do in fact get one. So just be cognitive of this fact and make sure that you really understand the process and that you have 10% to lose if you don't get the property. All right? I will make sure that that doesn't happen though. Oh, next, here we go, next. All right. Things you should know to help you. I'm going to share with you next some things that is going to help you, really help you. You're going to like these things. Now, coming up, this is not legal advice. These are strategies, but some people might consider it legal advice. That's why I gave you the legal disclaimer. So these are strategies that I use. There are other strategies that I use also that I'm not just fully disclosing to everyone. You're watching my presentation, you're understanding my expertise and my skill level. If you're interested in working with me, you can call Quintella Griffin of Ward's Realty at 925-237-1310, or you can email me at agentqrealtor@gmail.com and book a listing appointment, or you can book an appointment with me if you are a buyer or an investor who is interested in buying probate properties. So let's go to the next portion of this. Things that you should know that will help you. These things are going to help you a lot. Hi, I'm back. How to walk away with inherited property positive equity. I'm going to share this with you. Okay, I see so many people leaving inherited properties on the table. They don't want to deal with it. They walk away with it. They leave it for months. It's the property is damaged. They feel like it's not worth anything. Oh, it's just a raggedy old house. It needs new windows. It needs new this. It needs new that. It's not worth anything. Well, most likely, if you live in Northern California, it's worth something. You'd be surprised how much it's worth, because if you don't check into it, you don't know it. But you can call me and I'll tell you if you have positive equity or not. So Just hear me out on this. You gotta hear me out on this. Okay, if you inherited a property with a mortgage or a reverse mortgage and you can't afford to pay it, sell it. Don't sit on it. Keep getting calls from the bank, stressing out about it. What am I going to do about my uncle or my aunts or my dad's house? Sell it. Walk away with the positive equity. Heirs and beneficiaries are leaving money on the table for the bank. You're also leaving money on the table for investors. Sorry, investors. You're also leaving money on the table to foreclosure companies that call you and say, I want to buy your property and I'll give you XYZ. And you really don't know the full extent of what you're doing. So listen to me. If you listen to nothing else I say in this presentation, in this video, do not sell your property until you know the absolute value of it and how much positive equity you have. So I was online searching the other day and I found this property in San Jose. And I want you to look at this presentation and look at what I'm showing you here. In San Jose, California, there is a property. And there's many of them listed like this. The estimated value of the property is 1.7 million. The outstanding loan amount on it is 300. You're going to walk away with the positive equity of 1.4 million. Once you sell it, that's how much you get to walk away with. You get to keep the equity that was built in the house if you sell it. Oh, I see these all the time. It just kills me. I call people day in and day out trying to reach them, telling them you have positive equity when they're in foreclosure. If it's an inherited property and the number's disconnected, they're not responding to emails. Listen, consumers, pay attention. Don't leave the money on the table for anyone else to get. Get it yourself. Here's another example. The estimated value of the house was $508,000. The balance owed on the property, $140,533. You're going to walk away with over $300,000 in equity. You can divide that. It might be one heir that walks away with all of it. It may be two heirs. It may be however many. But it's better to sell and get the positive equity than not to walk away with it at all on the inherited property that you had inherited. So if you're going to sell, just think of this. Envision yourself walking away in the sale with the positive equity in the home that you inherited, that you didn't pay any money for, that you never made a mortgage payment on it. But you got to take action. You got to do something other than not pay attention. All right? If you have this issue going on, feel free to give Quintella Griffin with Ward's Realty a call, and I will tell you whether you have positive equity. And if you don't have positive equity, I'll tell you some other ways that you can save the property. I don't stop until the fat lady sings. That is real talk. So you can reach Quintella Griffin of Ward's Realty at 925-237-1310. Next. How to save your inherited property. Here's one for you. You inherited property only to find out that the person who passed away was not paying their mortgage payments. And now you, as the personal representative or executor, is left to deal with this matter. You may be the only heir, or there may be several heirs, and you really just don't know what to do. As a matter of fact, you have a sale date in 5 days. What do you do? This is what you do. If you want to stop it immediately, you may file bankruptcy. Now, you cannot file bankruptcy for a deceased person. Dead people cannot file bankruptcy. Only people who are living can file bankruptcy. But let me tell you, this is some information for you. Heirs or beneficiaries can file bankruptcy, and they can list the inherited property as an asset. And when they list that inherited property as an asset in their bankruptcy, that is going to put an automatic stay on the property, and it is going to stop, put everything to a hold. That inherited property that you have is not going to be sold in the auction. It will not be sold. This will give you an opportunity to figure out what you need to do. Whether you want to sell it, you want to go through the entire bankruptcy, or what. Now, here's the problem that you got to figure out. Which one of the heirs is going to file bankruptcy? Because it is going to ruin your credit when you file bankruptcy. That's what happens when you file bankruptcy. It messes up your credit. So you have to make an executive decision. If you want to file bankruptcy, and do you want to list the asset that you are a beneficiary or an heir to stop a foreclosure? You also may ask your attorney to file a motion with the court to stop the foreclosure. That's another alternative that you can do. Talk to your attorney. There is a such motion. Discuss it with your attorney. What type of motion you need to file to try to stop a sale while you are in the middle of a probate, going through probate. The courts are pretty good about giving you reprieve on that, but you need to have an attorney that can help you with this. All right? Problem solved. Yes, it is. How to save your inherited property. Now, I don't know if this is just something I know, if this is a secret or what, but I'm going to reveal it to you. This is not a secret. It's not what you know, it's who you know. How to save your inherited property. Say you are an heir or a beneficiary and the property is delinquent. You owe property taxes, it's in foreclosure, you need funeral expenses, you got to pay for the funeral. It's so many things that you need to do. You want to save the property so you can sell it and get the money back, right? This is what you do. Here's the answer to that question. Listen really good. You're going to get an advance on your inheritance, or you're going to get a loan, one or the other. Same thing, advance/loan. Guess what? When you get a loan or an advance on your inheritance, they're not running any credit reports. They're not looking for a high FICO score. You can have bad credit. They don't care what your credit is like. That's not what they're looking at. They're looking at the petition to see if you are in fact an heir. They're going to want to see that. The personal representative or executor or the attorney that you work with, they're most likely going to want them to sign some type of form. And pretty much that's all that it takes for you to be able to get money prior to closing escrow, prior to anything. You just have to show that you're an heir. Now, you can go to my website for information on 2 lenders that I work with frequently that can really help you out. Go to sellahouseandprobate.com/service-hub. Scroll all the way down to the bottom, and I have 2 lenders that I work with that will help you get a loan/advance. Problem solved. Don't let it go into foreclosure. Don't sit there and let the property taxes continue to get more fees. Don't sit there and say you can't pay for the funeral. If there's real property involved, that's an asset. And if you're an heir, you can take an advance or a loan. There's several companies out there that'll give it to you. It's just that no one talks about it. You have to be in the know. I'm telling you this. Go to my page, sell a house, and probate.com. It's right here in the presentation. If you need further information when you go to my website or you got questions, you can call me or you can call the loan officer. Basically, they're going to take your app, get your information. Again, you do not have to have a high FICO score. You don't even have to have a FICO score. They don't care. No credit is required. That's not the criteria. The criteria is you must be a beneficiary. You must be able to prove that you're a beneficiary. And they might have a few other criterias. So go to my page, check it out. Problem resolved. Next. I told you I was a smart agent. All right, we're continuing on how to save your inherited property. All right, just say, for example, you don't like any of the things that I just previously discussed with you. You don't want to take a loan or an advance. You don't want to file bankruptcy. You don't want to sell it. Okay, here's your last option that I'm going to tell you in this presentation. There's more, but this is what I'm going to give to you for right now. These are the resolutions. If you are an heir or beneficiary that inherited a property with a mortgage or a reverse mortgage and you need to pay it off, if all else fails and you just really don't like any of the options that I gave you, take out a hard money loan. Never let the bank foreclose on the property if it has positive equity, because guess what they're going to do? They're going to sell it and they're going to get your positive equity. If you sell it to an investor, he's going to sell it and he's going to get your, he's going to flip it and get your positive equity. A foreclosure company, they're going to do the same thing. They're going to offer you, oh, we'll give you 10 or 20,000 and we'll pay the balance off, and you walk away with it, with and leave all that money on the table. No, don't ever leave the money on the table. Do a hard money loan. Yes, the interest rates are high, but this is what you do. You do the hard money loan for 6 months or a year until you guys can figure out what you want to do when your head is straight and your mind is settled, and then you refinance it to a conventional loan or to a regular loan. It gives you time to think. It gives you time to figure it out. I work with Leonard Jones with home funding. He's a great guy. I call him the hard money king. We joke about it. Uh, if Leonard can't get it done, it can't be done. That's the honest to God's truth. You can reach Leonard Jones at 925-437-3003, or you can email him at ljlon, excuse me, ljlons at gmail.com. So basically, Leonard Jones Loans at gmail.com. Tell him Quintella Griffin from Ward's Realty sent you and you saw my video. He'll help you. He definitely will help you resolve this problem. So I've given you at least 3 or 4 ways that you could fix this problem. If you inherited a property that has a mortgage that you can't afford to pay, or you don't want to pay, that you want to sell, if there's an auction, how to stop it, not just by bankruptcy, but there's a motion that you could file. Talk to an attorney about it. Don't wait to the last minute. It takes time to write documents. Give the attorney the same courtesy that you would want to have done. So do not wait. Do not wait. Do not hesitate. If you need assistance with this, you can call Quintella Griffin at Ward's Realty at 925-237-1310. Thank you. I would actually be less than human if I didn't help you find a good attorney. So I have some attorneys that I know that I work with, that I can refer you to, or you can go to the California State Bar and they have an attorney referral service on there. I think it's like $35 to consult with an attorney. Believe it or not, you can go on LinkedIn if you have a LinkedIn account, linkedin.com, and you can post on there, hi, I am looking for a fabulous probate attorney. Please inbox me if you can help me. You'll get a flood. Go on the California State Bar, though, and check them out and make sure they've never been disciplined. You don't want a probate attorney that you're going to end up with, that you're going to end up with another one and another one and another one. I meet people like that in probate sales all the time. They go through attorney after attorney. So you just want to get a good one to begin with so you don't have to get another one. So these are some ideas. I can give you a referral. You can go to the California State Bar, and there's a link for referrals. You can go to LinkedIn, which is a professional website where professionals network together. It's really fabulous. I use it a lot. And you can post some information and they'll inbox you. If you're looking for a referral, you can call Quintella Griffin of Ward's Realty at 925-237-1310, or you can just email me at agentqrealtor@gmail.com. If you're an attorney and you're watching this and you want to help my clients and you want to help me and you want to refer probate listings to me, or you think we'd be a good match to work together, you can go to my website, sellahouseandprobate.com/attorneys-information. Fill in your information and I will call you and we can chat. And I can tell you more about my skills and my expertise and how I can make your practice better. All right? Thank you. So, you're in pro per and you represent yourself. Well, everybody's entitled to represent themselves, but sometimes you do need an attorney for things. So I thought I would share this information with possible viewers of this video that can get affordable legal assistance. It's called unbundledlegalservicehelp.com. So you go to that website and you tell them what you're looking for. They got different areas of law, and basically what it is unbundled legal services, where the attorney might appear for special things like a hearing or something like that, or they write a brief for you, but they don't represent you for the entire case. And so they only represent you on things that you really think you need to be represented on, or help with certain things. So it's like limited representation. So rather than just be straight self-represented in pro per, you might want to try this method if you think this method works for you. So again, if you are looking for affordable legal assistance and you want unbundled services where the attorney will just do specific tasks for you, go to www.unbundledlegalservicehelp.com. Check it out. Call, have a consultation. Do your research. It's best to do your research than not to do your research. And this is an option to you that you may have never known existed. Thank you. Thank you for watching my presentation. And my motto is sharing is caring. And I love to share. I love to share all the information that I know and that I've learned. And I just think it's really important that we share information. So I appreciate you taking the time out of your schedule and out of your busy day to watch my presentation. If you like, you can schedule an appointment for a complete analysis of your property, your home evaluation, positive equity analysis, and if you want to make a listing appointment, if you're a buyer and investor or interested in purchasing probate properties, I specialize. I know my stuff. I specialize in probate, trust, inherited property sales, as well as foreclosures, divorcing homeowners, bankruptcy sales. Yes, properties sold in bankruptcies, and traditional sales, and some light commercial properties. You may give me a call at 925-237-1310. You may also go to my website, sellahouseandprobate.com. You can check me out. If you need some information about probate, I have a guide for you, a guide to navigating an inherited property sale. Feel free to hit me up, send me your email address or whatever contact information, and I'll get it off to you. Again, this is Quintella Griffin with Ward's Realty. Thank you for watching my presentation, and I can be reached at 925-237-1310. Goodbye. Have a great day.